from supplementary list. Item number 1.
Keep it in a plastic folder. We did several times yesterday. Yes, madam. You were on
Yesterday,
second IO.
second IO, my lord, we had completed.
Concluded, yes.
We had concluded, and I was about to place the judgment passed by the High Court.
We'll come to judgment right at the end.
This is reason being, we are on 164 right now. So this judgment is on the state
All
of
right.
being
Oh, oh.
My lord, I have given a list of books. The citation is 1995, volume 3, GLR, page 443.
Nineteen
1995, my lord,
1995, sorry.
volume 3,
Volume 3,
3.
GLR,
Page number 443. Paragraph 7, my lord. Seven and 8. Page number 448. The term used in the
at 448,
at 448, paragraphs 7
7
and
and
8.
8, yes.
Now, the term used in this particular judgment is a confessional statement. In our case, we are using the term statement under 164.
It's not a confessional statement.
But my lord, both the statements, the evidentiary value of both the statements is the same because it is under section 164 itself.
No, the quality of they are different. 164 statement, these statements were taken on oath. Were they not?
No, my lord.
They were
Not
not.
on oath.
So they are in the nature of confessional
Yes,
statements. Yes.
If I may read now, paragraph 7. The aforesaid observation has been quoted by Supreme Court in its latest judgment, Chandrakant Chimnalal Desai versus State of Gujarat, reported in 1992, 1 SCC 473. It is held that one cannot rely on the confession alone to find a person guilty of an offence unless other evidence are present, which independently or near independently can hold a person guilty of an offence. The confession can only be in aid to the available evidence, but confession cannot be treated as the base document around which the rest of the evidence would circle. The Supreme Court in Union of India and others versus J.S. Brad, reported in 1993, 1 SCC 176 at 180, relying on a large number of cases, held that confession as such is of no value, particularly when it is retracted, except as a reassurance when reliable evidence has been used on behalf of the prosecution. Now, relying on this decision, my humble submission is the statement under 164 in our case is of no value. Reason being, the said statement under 164 has been retracted,
No, it has not.
and there is no other.
It has not been retracted.
There is no other evidence, my lord, on record.
There is no retraction.
My lord may consider the 313 not to be a retraction.
No, not at all.
My lord may consider that, in my humble submission, my lord, the answer to question number 15.
Have you thought of the matter, madam?
My lord,
Instead of seriously looking at judgments which have no relevance. Have you thought of the matter? Why is, tell us, analyze it, use the great rights. Tell us why is confession only treated as another piece of evidence for corroboration and confession is not taken as the be all and end all. When you say this, you must also keep in mind section 229 of the Criminal Procedure Code. Are you aware of that? I think it's 229. I'm not so conversant with, but I think it's 229.
229, conviction and plea of guilty.
Ah.
Now, plea of guilty.
Both are on similar lines. In 229, you know much more.
The guidelines are much more elaborate.
In 229, a mere statement that I'm guilty without the guilty part being in consonance with the other evidence cannot be taken into account. Particularly in a cognizable offence, a court rarely relies on this, even if you. Now, there is a different thing to a confessional statement. First, 164 does not cover only confessional statements. 164 covers every kind of statement made. Why? Because it gets an elevated status. Because 161 is barred by 25 to 29, is barred by 24 to 29.
Except 27.
27 is an exception to 24 to 29. Because the 161 is not admissible, therefore it is there. That's number one. Number two is 164 also incorporates 164(5), which is the basis for a confessional statement, and therefore the procedure under 164(5) is different than other statements. In a confession, you don't take oath, you don't administer oath, and there are certain safeguards which are there in the printed form itself. These are supposed to be read out. You make the person who is confessing understand, and then you also give time for reflection. All right. Now, once that is done, a person in a lawful position who is required to do an act in a certain way can be presumed to have done it in that way. That's also evidence. Now, why is confessional statement treated as corroborative and not primary? Say a mother comes and takes the blame for killing someone to save the son. So that mere confession by the mother would not be enough. It has to be consistent with the evidence which is available. So therefore, in many cases, confessional statements are not given primary value because of the fact that someone takes the blame for someone else, someone tries to misguide. Here is a situation where even though it is a confessional statement, and it will be very difficult for us to express this, that's why we are explaining it. Even if this is treated as a confessional statement, there is no confession of the offence that they have been charged with.
That is the fourth point, madam.
So therefore, this is confession of their association with the victim. Why did they then come and make this statement? They made it voluntarily. No one put a gun to their head. Why did they make this statement? There you must understand human conduct and psychology. The date was very close after they were very close to their being arrested. At that point of time, Bernard knew that the game was up. Because Bernard knew that Bernard's association with Biplav on 18th had already been discovered. Bernard therefore implicated his cohort. As the IO has said, Bonnie was picked up on the basis of being implicated by Bernard. Bernard made a confessional statement, a statement to which he admitted some role, did not accept the charges, did not confess to having killed, did not confess to having kidnapped for ransom. But Bernard made a limited confession to the extent that he was with the deceased at the time of the death of the deceased. Then comes Bonnie. Bernard says Bonnie killed, which is something we cannot use against Bonnie because of the Evidence Act. And it's something that you're trying to absolve yourself by blaming the co-accused. It's a cardinal principle, we cannot use it. Bonnie also knows that the game is up. He cannot just say that I was on the moon on that day, or I do not know who Biplav is, or that I never met Biplav in my life, or that on that day Biplav and I were not together. He also admits the incident which took place. The admission over here pertains to the incident which happened at the cemetery at Mauro or Marvo, whatever that is. Mauro. It only is that. Now, this is not to be mixed up with the other kinds of confession where just to evade, just to distract, just to deviate or take the blame, you must go to the root of it. You cannot take three lines and say that this is what the judgment says. You must go to the root of it. Why will I confess? Confess to having committed the offence. One reason, I have done it. Guilt, guilty mind. Two, remorse. Guilty mind. Two, remorse. Three, I know it's up, and at least a confession may lessen the punishment. In most cases, a confession lessens the punishment. Now, over here, there is no confession of the offence, but there is confession of the association because their guilty minds told them that the game was up. They could not hide the fact that they were with the deceased at the time that the deceased died. So we are not using any confession. We are using only their statement, their admission that they were with the deceased.
That is why they brought in this particular judgment. The term used is confessional statement.
May have been.
Yes, also it is a statement under one.
No, it is a confessional statement. To the extent, as you say that it was oath was not administered, it's a confessional statement.
Yes,
but it's not a confession to the commission of the offence. It's a confession of being with the deceased at the time of the death of the deceased. Because neither of them take the blame. Bernard does not say I killed him. Bonnie does not say I killed him.
Both of them are saying their statements are very much there on record, and
so this kind of a statement has to be treated differently from where I come and say, and I'll tell you there was a case of a man having beheaded his wife in Calcutta. A man beheaded his wife, brought the head to the police station and confessed that he had done it in a fit of rage. The police thought it was an open and shut case and conducted no investigation, produced that completely inadmissible. So that's because the law is like that.
In this case, my humble submission is first,
you have not thought of what is the purpose of 164. You have not thought of any psychology of the maker of the statement. You have just gone on cold lines in a judgment. We'll distinguish it. We're just telling you. We'll distinguish it.
The reason, this is a statement under 164, and every single statement which has been made in this 164 does not corroborate with the other evidence.
Where are you? Which planet are you on? Everything that they have said falls into place.
Marot, the post-mortem report, it is an expert opinion.
So,
It is absolutely contradictory
So,
to the
ocular evidence is better than any expert evidence.
18th of December, 18th of February 2006, it is being stated. But post-mortem report, it says 20th of
Ocular evidence is much better than any kind of expert evidence is an estimation. Ocular evidence is direct.
even in ocular, my lord, none of, there is no eyewitness.
What is the need of an eyewitness?
There is no eyewitness.
The man comes and both of them say, where is the need for an eyewitness?
The
Anyway,
phone call was made.
proceed.
It's not-
You don't understand 164. You've got to understand the basis. You've got to understand human psychology.
To satisfy the statement, the
There are-
in place.
Mr. Khan hasn't shown 164. If we want to, we can take out 164 cases and show it to you. Not of judges these days who don't know the law, but 20 years, 30 years back when they knew the law.
But we cannot say that.
No, we are aware. This is a great judge, by the way. Sudhir Burman Roy was master in criminal. Absolute master. He knew it. Many people wouldn't know it as much as he forgot.
My lord, this is the only judgment I wanted to place on one.
Should have got better judgments. There are better judgments. Much stricter application of 164 recently of the Supreme Court, which will come to your aid if you just look at the cold print and not look into the incident in the backdrop of which the statement is made. Now, over here, what were the facts in this case?
I actually don't completely remember the facts, but the statement has been retracted.
See, that is the problem. You apply the law when stated, weigh the facts. So, if you don't know the facts,
I'm on the principle of law.
what principle of law? Principle of law depends on facts. There is one passage.
The Bhavnagar University case deals with that.
Which one?
Bhavnagar University case.
What does it deal with?
That a precedent is applicable only when the fact.
What is the Bhavnagar case? I'm not aware.
The year I don't remember exactly. It's in 1990s only, my lord. Bhavnagar University case, and it was.
No, there's a passage. You open old cases, you'll find there's a passage of Lord Halsbury in, I think, 1895 or 1896 appeal cases. The parent judgment is called Quinn versus Leadham. Quinn and Leadham is quoted everywhere,
Yes, ma'am.
down the ages.
It was quoted when we were not IPC.
Quinn and Leadham is not IPC. Quinn and Leadham is a general proposition on law. It's not on IPC at all. It's in a civil matter.
But we were.
It's on the efficacy of precedents. And you read it, try and understand it. I've read it about 100 times. I've still not fully understood it. But I quote it very often. But you read it, and you read it in the context of one of the better cases where you'll find 1959 Bengal immunity, where the full complement of Supreme Court sat together and decided constitutional issues. You read those, you'll understand what it means. That law is never logical. Law is not logical. And therefore, every statement which is said is not an edict on stone when it's in a judgment. It has to be seen in the context. So let us see what facts were there and let us see if they are comparable.
The appeal was directed against the judgment and orders.
Let us see the nature of retraction. No, don't waste time. Let us see the nature of retraction.
Paragraph 6, Malad.
Yes.
In his confessional statement, accused stated that he, along with Hema
Hema Gogoi,
committed
committed
the murder. According to him, it was Hema Gogoi who dealt the first dowel blow, and thereafter he dealt 2 dowel blows on her neck. In his confessional statement, he stated that after hitting her, they, the accused and said Hema Gogoi, threw the dowel at the place of crime. Later on, the same was shown to the police. The said statement had been subsequently retracted at the time of examination under Section 313 CRPC. In his statement, he denies that police recovered the dowel being shown by him. He also denied that he had killed his wife. Similar in our case.
No, we don't have the facts have not been properly. No, it's not Justice Shuli Brahmana's judgment. Then he would have referred to the relevant facts.
Judgment is by.
Yes, sir. Both are Calcutta judges.
Now,
Yes.
taken to the next point, my lord, which actually yesterday I had taken as the first point, but it missed somehow. Now, the next point is on Exhibit 3, page number 409.
What is Exhibit 3?
Exhibit 3, my lord, is the seizure list of the PCO bill, to which a phone call was.
Now tell me, was the PCO bill shown to the PCO owner in course of examination?
No, my lord.
PCO owner was not called as a witness.
My lord, the PCO owner was called as a witness.
And the PCO bill was not shown to him.
Malai PCO owner, he does not recognize the accused statement given by PW 17, does not have. PW 22 is the PCO owner.
Let us see.
PW 22.
So you will cite judgment in fits and bursts. You will not cite all judgments together.
My lord, the very first judgment I have already cited on a previous occasion, I may repeat it today again. 2 judgments, in fact. One was on exculpatory confession, and the second was on the powers and powers of the
There is no exculpatory powers of.
exculpatory confession.
Anyway, repeat that because we've taken it from afresh from yesterday.
My lord. On exculpatory confession, my lord.
Will come. So do all the judgments together. Now finish the facts and do all the judgments together. Let's come to PW 22.
22. Page number 278 of volume 1. It is the title.
Yes.
May I read now?
What is the Ramgad down?
Headman. PW 22 is the PCO, Malai PCO owner.
Page 200 and?
278.
All right. But I got the wrong. Sorry.
That was the second witness with regard to
Yes.
seizure. In this, may I read, Mala? I am now presently residing at Maulai Moro, Shillong. I have got a PCO which belongs to me at Maulai Moro, Shillong. Many customers used to come and use the PCO on payment, and the identity and particulars of these customers I am unable to confirm, as the customers come and go after they have made use of the PCO. On 18/2/2006, some persons came to use the PCO, and on the following day, on 19/2/2006, the same persons came asking me to withhold our identity for using the PCO, and on further inquiry by me as the PCO owner, they said that the matter is in connection with the death of a certain person, but the person who is dead was not disclosed by those PCO's user. Those people, after the said conversation with me, left my PCO counters. I will not be able to recognize those people again if I met them. Crossed by Boni Malot, I have not given any statement to the police, as police have never examined me in this regard. It is not a fact that whatever I declare.
Very good. Now show us Exhibit 3.
Exhibit 3, Malot, page 209. 409, sorry, Malot. 409 of volume 2.
Four zero nine.
Malot. 409, volume 2.
No, where is the bill?
No, the bill is exhibit 1. The bill is at page number 401.
401.
It has been marked.
And the material entry is?
The last one, my lord. The last entry at page 401. It has been marked. It has been inserted.
It starts at 399, I believe.
Yes, my lord. It starts at 399. But the material entry is at page 401.
Page 401.
Now, my lord, this particular PCO bill was not shown to the PCO owner.
That's
and
all
he
right.
has not exhibited that this particular bill belongs from the.
Yes, so we'll have to analyze whether the effect of that is that we have to throw it out altogether.
Mark.
So that's what we have to analyze. A, to you, you're an intelligent human being. Does it look like an ordinary PCO bill? It does.
It does, my lord.
It does.
But-
Now the question is whether it's authentic or not. Now let us see what you show.
The first question which arises from this particular PCO bill, my lord, is that whether this PCO bill belongs to that particular PCO owner's PCO or not.
All right.
That has never been established.
Very good. Very good. It may or may not be. All that we need to know is Nirvika says
Mark.
that she received a call at a particular time.
And that too from Mohan, my lord, not from Mohan.
Whatever it is. She says she received a call at a particular time.
Mark.
All right? Whether there is any evidence of a call going to her at or about the same time.
It is correct. That is true.
So therefore, that fact is established by this. Now, who produces Exhibit 1?
Exhibit 1, my lord, on 19th of February, when the friends of the victim went for a second search of Biplab, they came to this particular PCO.
Roger.
Roger and his team.
Who refers to Exhibit 1 in the evidence?
In the evidence, my lord, it is PW1.
PW1 is the Purkatsu.
The local guardian of
Yes.
the victim. He has stated in
Let us see what he has stated and let us see how you have demolished it.
PW1 now. Page number 84. Now, the relevant portion with regard to the PCO part is at page 86. If I may take your
When is this? This is on 19th. This is on 19th.
19, it was taken from
19th, on 19th, which was a Sunday. So, 6. So, on 19th Sunday, then, first we went to Laban. Then we thought of going to meet Nirvika at her residence in Police Bazaar. Friends of victim told me they had contacted Bernard, who said that he would also come to police bazaar. My wife was also on reaching Nirvika's house at Thana Road. She went inside and talked to her. Meanwhile, Bernard also came to police bazaar. He told me that he was with Biplav at police bazaar on the previous evening, and Biplav had left in a white Maruti car bearing so and so. So you see, his evidence is there.
Hearsay.
He also, what?
Hearsay evidence.
He directly says that the accused told me. Where is the accused cross-examination on that? You're lying. Where does the accused say you're lying?
That's what Bernard.
You don't have an idea. You're doing a criminal appeal. What is the hearsay evidence? Hearsay evidence does not apply to the accused. Hearsay evidence applies to third parties. He is saying, you, the accused, told me. That's not hearsay evidence. That's direct evidence against the accused. The obligation of the accused is to say you're lying.
My lord was asking me about the PCO bill from where it.
Forget that. You don't have the least idea of evidence. He also said that there were two more persons in a car, and Biplav had told Bernard that they were Biplav's friends from Siliguri, and all of them were going to drive to Nampo. He also, Biplav asked him to accompany, but he refused. So he told Bernard that in case we would have to file an FIR and he can accompany us, because he was the last person to see Biplav. He said that he had no problem, but then he had some important work first. All rest just stay. So accompanied by all the other friends except Bernard, we first went to civil hospital to whether there was any report of accident. From civil, we went to Limukra police station, filed an FIR that Biplav had been missing. The friends also gave some photograph of the missing boy from police station. Meanwhile, one of the friends of Biplav, namely Roger, said that he had been able to find out Biplav's telephone call to Nirvika in the previous evening had been made from a PCO. He could find this information, as told to me, because his mother works in the police department. He also said that the PCO was located at Mauro, and Roger had already talked to the PCO owner on telephone, and that person was willing to meet us. So accordingly, we went and reached the PCO at Mauro in the resident area. We showed the photograph of Biplav to the PCO owner, who could not exactly recognize, but nevertheless, he gave us the printout of all numbers where calls have been made on the previous day from his PCO. In that printout, we found the number of Nirvika. Upon being shown in the court now, I recognize and identify the said printout handed over by the said and exhibit the same as exhibit and exhibit 1. All right. Now let us see the cross-examination. Bonnie.
Page 89 now.
Let's see Bernard first because Bernard is relevant. Bonnie, he did not make any.
Page 90.
I had not stated about lodging FIR at Raipura in my statement. As advised to lodge the FIR before Shillong Sadar police station. Friends of Biplav informed me that Biplav was last seen with accused Bernard in police when they came to know
From Miss Nirvika.
from Miss Nirvika.
Nirvika says that.
Just a second. Let's finish. It is a fact that in my FIR and my statement before the police, I have not mentioned anything about Exhibit 1, that is the PCO printed out roll. However, I verbally had communicated the same to the police. I cannot recollect that whether material exhibit seized or wrapped by the police after seizure. I am not sure that it is the same which was seized from the father of the deceased. Exhibit 1.
Now, my lord, at one place he says that Exhibit 1 is the.
Anyway, we'll sort it out. No, don't worry. I'm sure that material exhibit. What is material exhibit? Material exhibit 1 and exhibit 1 are same or are they different, Mr. Khan? They're the same. Anyway, I'm not sure what is the same which seen from my father, but I believe it to be same. So from the father of the deceased. It is not a fact that the statement which I have given you is false, fabricated, concocted story. Now, Where is Bernard's questioning?
That was Bernard's questioning.
Where is Bernard's questioning that I did not tell you? Please, those all have to fit the chain. He did not say anything about Bonnie. He only said about Bernard.
Yes, ma'am.
What did he say about Bernard? That Bernard joined us. Bernard made some excuse for not going to file the FIR. And Bernard also said that Bernard was with Biplab the previous evening, and then Biplab left in a white Maruti car or something like that with two of his friends from Chiliguri. So this is Bernard's statement. Now who best but Bernard to counter that?
This is the same statement, my lord, made by Biplab to Nirvika.
Very well, very well. So Bernard was with Biplab on the 18th is proved from this, because Bernard does not question it. Now, Purgasto does not know anything about Bonnie. So Bonnie, he has not made any allegation about Bonnie over here.
Bonnie's cross-examination is important.
We'll see that. Let us look at it. Let us look at it. But Bonnie's cross-examination has nothing to do with the examination in chief.
Not with the examination in chief, my lord, but with the Exhibit 3, my lord.
Yeah, very good. Let's see what Bonnie says.
Not page 89.
89 years.
Bonnie has questioned and PW1 has stated. My statement was recorded by the police in connection with this case. Whatever I have stated before the court today was given to the police. It is not a fact that my statement before this court is an added version which was not given by me to the police earlier. On 19/2/2006 at about 1:30 and 2 p.m., David Holmes, Kaushik and other friends of Biplab informed me that Biplab was missing from previous night. I asked them why they have informed me at a belated stage, but they said they were expecting him to come back. Then on 19 February 2006, first I went to Laban, as all the friends of Biplab, including David Holmes, told me that most probably the mobile of Biplab can be charged through the Airtel service provider from others' mobile. Police has not sent me for recording my statement by a magistrate. When we went to Laban for recharging Biplab's mobile, I cannot remember whether David Holmes did not tell me that Biplab was carrying his mobile and David Holmes was carrying Biplab's mobile. It is a fact that the father of Biplab Das rang me from Siliguri while he was on the way to Shillong, that he has already received a phone call from some unknown person who demanded rupees 80 lakhs for release of Biplab. The phone call came around 6 p.m. on 19 February 2006, the next day, Mara. Exhibit 2 was lodged by me at Sadar Police Station around 10 p.m. The date of missing of Biplab Das reflected in Exhibit 2 as 18/12/2006 is a mistake. It is not a fact that I have committed a mistake in respect of mentioning year and date and month is correctly stated. It is a fact that I have not mentioned about the demand of money to Biplab's father in Exhibit 2 as applied by the police. It is not a fact that police has not advised me while writing Exhibit 2 not to mention about the ransom. Lord, the phone call was at 6 p.m. The FIR was lodged at 10 p.m. But the fact of ransom being demanded is nowhere mentioned.
Yes.
It is not a fact that the demand of ransom is concocted by us to give a color and motive to the murder. Material Exhibit 1 was seized by the police from the father of the deceased. I had no occasion to view the piece of material.
What does that word FPPS? Some mistake. No view to.
I have not seen or
I had no occasion to view whatever of material Exhibit 1. I have not seen or noticed the injury mark
on the bodies
of the deceased.
I was standing by the side of the graveyard, and while the police was preparing Exhibit 4, I was standing by the side, and after preparation of the report, they called me and I signed on it. I have received Exhibit 1 on handing over by the TCO owner in front of the club's friends. On 22/2/2006, I have handed over Exhibit 1 to the police. Now, my lord, here he says that he has handed over to the police. Another place he says that PCO list were seized from the father of the deceased.
Whatever it is, he got it, and he says it clearly in cross-examination to you that he handed over to the police. And he handed it over on a later date.
Another seizure witness of Exhibit 3 signed on 25/4
As appeared from Exhibit 3.
as
All right.
from Exhibit
So now, there are many things. Why is a signature marked as a separate exhibit? Why is the main thing marked as a separate exhibit? Because all of them are different pieces of evidence.
The signature is always marked
You
as
are
a part.
all knowing. Finish when you tell us when you finish. Since you know everything, tell us when you finish.
I don't know.
Yes,
but
tell
I'm
us.
just trying
You are
to-
not doing good service to your client, madam.
I'm just trying
You
to-
are not clearing the doubts. You are going on a track which is detrimental to your client.
I'm just trying to.
You're not clearing the doubts. A man died. No martyr came and killed him.
That is very, very true, ma'am.
You proceed in your own way. You're not manageable. You proceed in your own way.
One
Yes.
clarification about that word FTTES appears to be files from the handwritten.
File. View the files. Whatever. It doesn't. It's not a crucial thing.
It was there in the original.
It's files.
Files. FILs.
Files. Yes, tell us.
My only thing is, my lord, with Exhibit 3 also, whenever a signature is marked, my lord, the witness's signature, it is marked as Exhibit 3/1, which proves that it is a part of Exhibit 3. In this instant case, my lord, if the lordship would kindly appreciate, the witness has not signed when the seizure took place. The seizure was in February. The signature is in April, my lord, and it is administered by the document itself proves it.
Yes.
My lord, now on facts, my lord, I have basically covered most of the aspects yesterday itself, my lord. This was just one point which had remained from my side, and this is my humble submission with regard to the facts. Now, my lord, the
You have not dealt with telephone.
dealt with, my lord,
You have not dealt with telephone.
telephone-
Mobile phone.
Mobile phone, my lord.
You have not dealt with. We are just pointing it out to you.
I'm
Since
deeply
that is in your favor,
I'm deeply-
you have not dealt with the mobile phone.
PW11. That skipped my attention. I'm deeply grateful. PW11. Page 176. As I recollect from yesterday, my lord, the IO had subsequently admitted that the phone
Yeah.
belonged to Bonnie.
Yeah.
So I would now directly take to PW11.
Yes.
If I may read now. I have received summon, my lord. I am working presently as bus conductor of Bajoria High School, Polo, Shillong.
No, come to the material part on
No,
18
the
to
material part in this.
on 18 to 2006.
Yes.
Approximately from there read.
Yes. That is the most important paragraph in
Yes.
this deposition. On 18 to 2006, at around 3 p.m. in the daytime, one person by the name of Boni Bhawa came to the said school to meet me and delivered me a mobile whose brand name I'm unable to tell at present and requested me to sell the mobile which was handed over to me. Boni Bhawa from his boyhood used to work in the shop of my brother-in-law named Rehman. However, I am unable to recollect at present the year when Boni Bhawa worked in the shop of my said brother-in-law. I know Boni Bhawa only because of the fact that he worked in the shop of my said brother-in-law. One of the relevant portion in the cross by Boni.
No, let's go on.
One.
Go on.
After 2 days from 18 February 2006, police personnel came to my residence at Norman Song, Shillong at around midnight, and police personnel entered my room when I woke up from my fast sleep. The police then asked me whether I had in my custody the mobile that was delivered by Boni Power. I replied in the affirmative and handed over the said mobile to the police as asked for. On the next following day, the said police personnel directed me to come to the Sadar police station, Shillong.
So the essence of this is that the mobile that was taken from this man, from Ayub Karkongar, was Boni's mobile and not Biplab's mobile. And that is consistent with the statement of Purkasto that Roger had Biplab's mobile, David has Biplab's mobile, and Biplab's mobile was with, or David's mobile was with Biplab. So that mobile was never recovered.
No, ma'am.
All right. So therefore, this is Boni's own.
Yes, ma'am. That is the statement given by Ayub because the phone was delivered to him at around 3 p.m. in the afternoon. And the statement of the Ayub as well as Purkayasta PW1, it tallies. with
Very
it
well.
and
What else depends on facts?
on
What about that part where Roger talks about the PCO person identifying Bernard?
Roger is PW17.
Yes, Roger, I think, talked about PCO person identifying Bernard. Whose statement was that?
PW17.
PW17, Roger.
Roger. Page 235.
Who was Akbar Qureshi?
Akbar Qureshi, my lord, he was.
He is a furniture man.
Yes, my lord.
Furniture man who used to work for Gania's father, Nirvika's father. But why was he apprehended?
Because one of the confessional statement, if your worship recollects, one of the accused said that there was earlier, prior to the incident, there was a discussion amongst the three as regards to having a good.
We'll come again to the confessional statement last, before we finish. Yes. Yes. Where does he say?
Page number.
According to my investigation.
This is 237.
Page 237.
I've got a completely wrong page. So it's 235, not 325.
It starts at 235.
Yes.
And the relevant
This is
portion-
Roger. Roger. And whose mother was with police? That's David's mother. Whose mother worked
Roger's.
for Roger's mother worked for?
Roger's mother was working in the police
Police.
department. That is what the PW1 has stated.
Yes.
And the information regarding the PCO owner, my lord, the relevant page number is 237. Sixth line from the top.
Initially, Bernard was reluctant to accompany us, but eventually he agreed to accompany us in search of Biplab. Then, along with Bernard and our team, we left again to PCO at Maulai
in the same tourist
through a taxi. Maulai and Maudo are different places.
My lord, Maulai is a huge area.
Maulai is the lower part.
No, ma'am. Within Maulai, there are different blocks. Moro is also a part of Molai. In the same way, we have areas like Yoringham. So these are small localities within Molai. So Moro is one of the localities within Molai.
Beyond Galton case. Okay, it's before that.
Sangej.
Okay, okay,
The route which goes to Nehu and the bypass Manor.
okay. Then along with we left and again in Maulai, same to we requested Bernard to inquire from the owner if he could supply us any information of the missing of Biplov. Then the owner of the PCO called me in a corner and informed me that Biplov had come. Bernard had come on 18/2 and told that he was.
And told that he, the owner of the PCO,
should not tell anybody or disclose that Bernard had come to his PCO on the night of 18/2.
At that time when we
Very
were in the
good, very good. Now, let us see what Bernard's cross-examination on this aspect is.
No, it's at the same page.
Yes. Now, what is the...
PCO
it is not a fact that me and my friends at any point of time did not go to PCO at Maulai Mauro. So therefore, Maulai Mauro is over here clearly is indicated. And there is no further cross-examination
It is there, ma'am.
on such aspect.
Page 238.
It's not a fact that the owner of the PCO did not inform me that it was Bernard who came on 18/2. So he is consistent in his statement. But of course, there is a cross-examination which amounts to a suggestion of denial. So that is there. See, over here, you cannot extricate. I shouldn't be trying to explain to you anymore, but still, because we are also not interested in hanging a person
Indeed.
who did not commit the crime. It's our responsibility to ensure. Similarly, it's our responsibility to ensure that justice is done.
Yes.
We don't know either Bernard or Bonnie, and they are young people. The last thing that we would want to do is for them to rot in jail. But you cannot, in this case, divorce yourself from Bernard. To the extent that Bernard has been found culpable or associated, that sticks to you also. Because all these people, from Purokasto to, they may or may not have any axe to grind against either of you. They may or may not. We don't know. But all of them point to Bernard's involvement. Bernard points to your involvement. To the extent that Bernard accuses you of commission of the offence, we disregard. But once Bernard implicates you, your admission is also there of presence with the deceased. There is no alibi. There is nothing else. You have, let us say, denied your admission at the 313 stage. It was then your duty, as a rational person, to try and set up an alibi that you were playing cards with another group of friends at that relevant point of time, or you were doing this. We don't know from the Guwahati case the circumstances of retraction or what was the statement. We are going to lay it bare and say why we do not follow that. But in the absence of any kind of excuse, all you require to, the only thing that you've done, both Bernard and you, is raise a wild doubt about the involvement of Nirvika's family because they may not have approved Nirvika's relationship with Biplav. But there is no evidence of marriage. There is no evidence.
No investigation of
No evidence, not necessary. They have gone on the line that they have thought right. You do not show any kind of marriage. You do not show any kind of animosity to anything else. It's just a wild allegation which has been denied, and we see a dead end over there. For us to have a doubt, in the midst of what is apparent, what do we see? We see that on 18th, let's be an outsider. On 18th, Biplav does not return. 19th, some friends go. Purokasto also goes. They go looking for him all over the town. Bernard accompanies them. Bernard does not come to the police station.
On the same day, he was taken for interrogation.
That's later. But Bernard does not come to the police station. Indicates something about Bernard. Next, they go to the PCO. PCO is now identified. That Nirvika got a call from that PCO is beyond doubt.
It was from a PCO she herself had also stated.
That is beyond doubt. Next is the PCO man saying this, to which there is a stout denial by Bernard. We are going with Bernard. We are setting the jigsaw puzzle. We are setting the jigsaw puzzle. Because once Bernard gets fixed, you fall in line. So Bernard's presence at the PCO is asserted to, denied by Bernard, but no more than that. Bernard does not attempt to demonstrate an alibi at that point of time. Bernard could have. Bernard says that they went in a taxi, Siliguri friends, whatever. Bernard does not attempt any alibi. Very important. Next, the telephone, the entire issue is a botch-up. We cannot hold it against you. None of the friends or the others associated with Biplav say a word against you.
They were never examined, my lord.
No. Roger,
Except Roger, no other friends have been examined.
Purokasto, they say not a word against you. Because they probably didn't even know were not even aware of your existence. So therefore, you can't say that these people have any acts to grind against you. You are implicated by Bernard. You have made no effort to dissociate yourself from Bernard. Bernard makes a statement, you have made a statement. The statements were made not in front of each other at different points of time. Certain parts of those statements corroborate and therefore encourages us to place credence on both the statements. You do nothing in your cross-examination of the magistrate. You go right in the end, say you did not, and you have said at least something. Bernard may not have said too much. You have said something that whole day I was there and it was not recorded. Subsequently, she made me sign, despite my not having made any statement. At least Bernard is not there to that extent. subject to correction by him. So therefore, we have to take your denial, your retraction with a pinch of salt. Because Bernard does not retract to that extent. Right? Now comes the PCO slip. Yes, there is a mistake in how the executive magistrate records the statement. There is a mistake in her not putting a date in one page, her putting a wrong date on another page. Those are things that should never have happened. But are they mistakes that take away the credibility from the contents of the document? No. Similarly, we do not know, to an extent, as we point out, we do not know how the PCO paper came to Purokasto or how Purokasto gave or when he gave. But the incident happened on 18 or whenever. Incident happened on 18, 19, 20th, let us say. Purokasto got, according to him, the paper on 19th and Purokasto made it over on 22nd to the police, according to Purokasto. Now, is it possible for Purokasto to have manufactured the entire roll of, if it was one slip, we could have, it's an entire roll. Now, as you know, they are kept in duplicate with a carbon paper behind the first. So, the receipt is given to the person who makes the call and who makes the payment. The roll remains. This appears to be a part of the roll. And the previous ones all indicate times which are anterior to the relevant call for our purpose. It's going to be very difficult for us to think that Purokasto, because he wants you to go to the gallows for no rhyme or reason, manufactured this role, created so much of false evidence by taking so much trouble without obtaining it from the PCO owner, and gave it to the police to frame you.
I don't dispute that part, Madam.
So if you don't dispute that this,
whether it is from that particular PCO,
it may be from anywhere. It says Maulai Mauro or whatever it says that in the thing itself. Maulai Mauro, it says it in the slip. You are absolutely correct that the investigation should have given this to PW11. Is this from your shop? It was not given, deliberately or otherwise. Sometimes criminals are also favored by the police. But does it make us doubt?
not just this particular document material.
No. Just a second. Will that lead us to believe that this is something that Purokasto left his work, went, had this entire thing fabricated to make it look like a PCO roll, and then gave so many numbers? There are other things you could have pointed out from here. You could have pointed out that this number is fictitious, the previous number is fictitious. You could have pointed out by getting this number, there are mobile numbers indicated or phone numbers indicated. You could have called any of those, answering to that no, I did not receive a call on that day. You would have.
Material exhibits are.
You would have doubted. You would have thrown some doubt on the veracity of the document. You do nothing. You have got this in your 207.
No, my lord, material exhibits are not given in 207.
You know, copies of these are not given in 207. Anyway, you got it. If PW1 said it.
Directly.
PW1 said it. Right at the beginning of the trial. PW1 comes and says it. And we have gone on to PW 33, 34, and so on. So you had maybe 6 months' time to discredit the veracity of this. And how you show is when it was serial list was signed and when he gave it and whether it was taken from the father. Let us say a stork came and dropped it in the police station. As long as we are satisfied with the quality of the material, whether the stork comes and gives it, or an angel comes and gives it, or a policeman gets a dream that it is lying behind someone's pillow, go and get it, is of no relevance. This, together with Purokasto's assertion, Rogers' assertion, fixes Bernard to Biplov on 18th. That is the evidence before us. Biplov's confession statement is the icing in corroboration of what we already have. And your statement is ancillary to Biplov because it tallies completely. Bernard and Bonnie's statement tallies completely with what Biplov says. We are not counting.
Biplov, what is the victim?
Sorry, Bernard, they all are B.
Yes, my lord.
Yes. So, and that to us, this is the wood that the trial court missed for the trees. Because it went into nitty-gritty. You see the larger picture. If the larger picture is incomplete or doubtful, then you go to the nitty-gritties to throw out. But you don't, over here we don't have to throw out anything. We start on the evidence that is before. And we go on to your confession, which is in consonance with the evidence which is recorded.
Except for the retraction one.
Retraction, we discredit the retraction. The mere retraction without a justification, if you had retracted and shown that you were playing cards with some other people on that day, on the day of the incident, yes, there would have been some value in your retraction. You have made no such attempt, madam. You merely just said, what kind of retraction do you make? You make a retraction by saying that I signed on a blank paper. You don't say that directly, but you insinuate that you signed on a blank paper when she filled up the imaginary statement on your behalf. Now, why did you pray, sign the blank paper? Did the executive magistrate, did the judicial magistrate was not the police? The judicial magistrate did not have a gun?
You were in custody till that
You were in the judicial magistrate's chamber.
time.
You were in the courtroom. There is no evidence of any police being there. The judicial magistrate did not have a pistol. The judicial magistrate did not have a danda. Why did you sign? The moment you sign somewhere, it is an acknowledgement of whatever is the contents. You could have.
The questions could have been put.
What questions?
Questions as to whether why did he sign or.
No. Nothing had to be put. Your signature is there is evidence enough. Are they fools like you that they will put questions to discredit their case? You have to demonstrate. The burden is on you to demonstrate how you put your signature on a blank document despite knowing that you had gone to make a confession and not having had made a confession.
I completely understand that your lordship has understood the case in and out. But it is my duty just to assist this honorable court.
To assist is in the right way.
Indeed, ma'am.
To assist is not to mislead.
But I'm not trying
To assist is not to mislead.
Not at all, ma'am.
Because everyone, even if you are appearing for
For whoever
the biggest criminal, it's your duty to look after his interests, but not by in a devious way. By the proper way, say that this is it. The effect of this in law is this. The effect of this statement, the inference that you draw from this statement is this. Not by pointing out. If it is foolproof, then we will start doubting.
But this particular statement, your Lordship has already stated that your Lordship will differentiate the judgment whether it is applicable to the present case or not. But in my humble submission, the first judgment, that statement under 164, is of no value. That is my humble submission before the Honorable Court, relying on the Guwahati High Court. Second, now, my Lord, since on the facts, if your Lordship has any other query, if I may clarify.
No, we don't have any queries. We are just explaining to you. We have no obligation to. We have no obligation to, but we're just explaining to you so that while we say, when you are saying something, if you are not being rational, if you are not being logical, if you are not being reasonable, you will hear yourself and correct yourself.
Indeed.
Which unfortunately you are not doing.
Now, my Lord, if,
Yes, the next judgment.
the next judgment, my Lord,
I think everything is clear now.
1987, Volume 2 GLR. Volume 3 GLR. 1987, Volume 2 GLR.
GLR
Page 100.
100. What is the proposition?
Proposition, my Lord, is on value of exculpatory confession.
Value of exculpatory confession. What does exculpatory confession mean?
Exculpatory confession, to my understanding, my Lord, if I am one of the accused and I am making a statement against another accused,
then we have said that we are not taking that into account. So why do we need to see the judgment?
but my Lord, just one paragraph, one small paragraph, my Lord, just for my satisfaction. The exculpatory confession.
Where is it? Paragraph?
Paragraph 8, my Lord. Second line.
Paragraph 8.
Yes, my Lord. Paragraph 8.
All the above relate to confession affecting the maker, that is inculpated. Now let us see the facts. Where are the facts?
The facts started paragraph
Trial
1.
court relied on the confession. On 5A, Omrit Corporation was carrying cash in such and such. Mr. Fukan accompanied Mr. Fukan in that tracker. The allegation was that 5 persons armed with deadly weapons suddenly stopped that vehicle near so-and-so and forcibly looted that amount. Who in this case of subsequently charged against 5 accused who faced trial. Witnesses, including all occupants of the tracker, deposed. All 6 were eyewitnesses of occurrence. They categorically deposed that they could not recognize the culprits. They failed to implicate any of the accused in any way with the occurrence of the dacoity. There was no other evidence to connect them with the crime except the so-called confessional statement of accused Mohan Chandra Roy. What is the statement? The trial court finally denied this confessional statement was recorded by NC. He could not identify accused one in the dock at the trial. So that also is the so-called confessional statement was received in evidence and marked exhibit 5. Trial court clear up held considered exculpatory one. On scrutiny of confessional statement was found to be clear, exceptionally once in detail about the plot of looting cash when it would be carried in the vehicle. He was not a participant in the looting of that amount. He did not express by his to have committed the crime, but in the conclusion portion he admitted to have received some portion of the boot of the booties. The trial judge was correct in holding that it was an exculpatory confessional statement. Trial court not only convicted on the basis but also convicted the 2 appellants as their names were mentioned by as participants. Rubbish.
But my Lord,
So do you think that this applies to our case?
Lord, in this case, your Lordship is saying.
So let us say over here today. Let us say in your case, forget your statements. Imagine your statements were never given. but the police is proceeding against you and against Bernard. Alright? And they have all the material other than your statements. Alright? Imagine now, David comes and says, I've committed the murder. Mohan Roy's statement amounted to that. He was not part of the people who looted.
But he received.
He claimed that he planned it along with two of the appellants. He also claimed that he had received a part of the proceeds. Alright? He had no business to do this because no one identified him, nothing. So in such circumstances, his statement, both the one that he made against the two other appellants and his statement, were found to be of no value. Now, what relationship does it? What kind of correlation or what link does it have to our case? I'm not saying that the facts must be identical.
No, it should be
Facts need not be identical, but they must be comparable.
But in this case, the two accused persons.
Just before you say, just one more interruption. Without Mohan's statement, there is no material against Mohan.
Same is the case.
No.
If we take the evidence, solely the evidence, then the scope of this honorable court is very limited.
You take your confession out. You don't take Bernard's confession out.
I'm not
Take your confession out and see whether there is any material against you.
Bernard's statement is that I committed the murder.
Bernard's statement about you committing the murder, we will disregard. But what about Bernard's statement of your presence in the graveyard at the relevant point of time?
The presence has nowhere been proved, man.
That presence is admitted by you. That's the evidence and the corroboration.
That is the retraction, man.
That is no retraction at all. We told you it's not retraction.
Maron, kindly just see paragraph 8 once.
Yes, you see
An
it. We read it.
exculpatory confessional statement cannot even be made binding against the maker, not to speak of his co-accused. Exculpatory confessional statement, although in descriptive form, is no confession against the maker in the eye of law, and it will be illegal to act upon such statement to convict the maker or his co-accused. The conviction against the two appellants was wholly unjustified. So, my lord, the conviction was set aside.
So that is as against co-accused. As against co-accused, we are taking into account. As against, there is no confession over here of the commission of the crime. There is confession of being with, and that leads to the, anyway, what is the other judgment?
My lord, there are two judgments on the powers of the appellate court.
Yes, that is the one that we want to see.
Yes, ma'am. There are two on these. The older one I'll take first, my lord, 1990.
Just a second, this is on,
Powers of appellate.
just a sec. Acquittal rarely reversed.
One.
Yes, what is the first one?
1996,
1996,
9 SCC,
9 SCC.
page 225,
Yes.
paragraph 7.
We'll come to paragraph 7. We'll look at the facts first. Thank you. We have told you the same thing, that we find the trial court missed the wood for the trees, but we'll use these exact words. That the findings are palpably wrong, manifestly erroneous, and demonstrably unsustainable.
Paragraph
We'll
7
use those exact words.
Paragraph 7 for
Yes, thank you. Paragraph 7, yes.
Paragraph 7. The sixth line.
We've seen it.
The sixth line. This court has repeatedly laid down that the mere fact that a view other than the one taken by the trial court can be legitimately arrived at by the appellate court on reappraisal of the evidence cannot constitute a valid and sufficient ground to interfere
The
with
first thing, first principle is that another view, before taking another view, the court has to be convinced and indicate why it finds the view to be completely erroneous. We find the view over here to be completely erroneous. We'll use those exact expressions.
as your lordship.
Yes.
Unless it comes to the conclusion.
Over. Finish, we've seen.
And my lord, again on acquittal,
Yes.
power on acquittal, the second judgment is 2000. The year is 2000.
2000,
Volume 4,
volume 4.
SCC,
Yes.
page 484, para 21. The powers.
Again, Mona Mukherjee.
My lord,
No, Wadhwa.
judgment by Miss
Wadhwa.
Madam Huma Pal.
She was like me. No knowledge of criminal law. She was brilliant otherwise, but
Paragraph 21. Now. Paragraph 21. The principal.
it's a quotation. It's a repetition. It's just a quotation from the previous judgment. Nothing new.
Not from this one, my lord.
Or different one. It's the same thing. Nothing new. Don't repeat. If you have anything new to show any other angle.
The other judgment that I rely on is discovery of dead body.
Yes. Discovery of dead body, we don't believe on facts.
My
But if you want to, you can. We don't believe on facts. That Bernard or Boney led to either the body or the murder weapon. We do not believe either.
So then I drop I will not burden, unnecessarily burden this one. So my last judgment which I may be permitted is the mode of proof of circumstantial evidence. Circumstantial evidence in this particular case, my lord, it has in no way the chain is complete. In no way.
Only the chain aspect you want to say. Just give us the thing.
1984,
1984,
volume 4 SCC,
4 SCC,
page 116.
116.
Yes, ma'am.
Circumstantial evidence, chain must be complete. A chain is as strong as its weakest link. So if the chain is incomplete, if there is anything which is consistent with any other probability, then the proof is not beyond reasonable doubt.
Paragraph 153, ma'am.
So that's the only spiel anyone can give.
Paragraph 153.
Paragraph 153.
So this is the conclusion of the entire judgment, paragraph 153. At page number 185.
One 180.
185, page 185.
Yes. Yes, maybe must be. Yes, all right. We'll set out 153.
With this, I
Thank
only say that this judgment, the impugned judgment, in my submission is not erroneous, neither unreasonable, and as such.
Thank you. Yes, yes. You are Mr. Sen. Dev. Mr. Dev. You have a bigger responsibility than her. If she failed alone. If you fail, you drown along with her. you take her down along with you. Because you're the person who gets Bonnie into the picture. And you cannot, a lot of what we've seen is, we've reached Bonnie only through Bernard. Independently, there's no way to get Bonnie, except through Bernard. So just make your points and then show us whatever you want to show. And so this is Bernard. Obviously, you will not finish today. No. We will not cut you out. Whatever you want to say. And madam, if after he finishes, you think that there is a point of law or a crucial fact that you have missed out, we'll give you a chance to even indicate that. Yes.
The first point was that who was the last person who saw as per the prosecution?
Who was the last person who saw?
Both the accused and the victim. Of the last
Both the accused and the victim alive. Both the accused alive, even we know the accused alive.
Who was the person who saw all the three alive
Together. No one saw them alive together.
Can you see?
Don't ask wrong questions to which there will be wrong answers.
Is that PW12 is one of the witnesses on whom the prosecution heavily relied before the trial court to show, my lord, that
You're also legal aid.
no.
You're engaged by Bernard.
Not so.
And she is legal aid.
Yes, ma'am.
Yes.
So what I'm trying to say, my lord, is that PW12, he is an auto driver, my lord. He says that both the accused.
No, sir. You forget that Purokasto says that you claimed you were with Bernard. You claimed that you were with Biplav. And you did not cross-examine Purokasto on that.
Lordship, that is on 18th.
That's on 18th, yes.
18th. The auto driver says that all three were in his auto on 19th, my lord.
He's an auto driver after all. He's not you, he's not me. He's an auto driver after all. 18th or 19th, what difference does it make to an auto driver?
No, because, my lord, he was immediately examined even by the police as well as in court. And he maintains it 19th.
If you're also all going on the I was not dotted or the T was not crossed, that will
I'm
not
just
get you
pointing out
anywhere.
the contradiction, my lord, that PW12 says 19th. That is the
But
only.
the VW says that it doesn't matter.
Not-
When you have told Purokasto that you were with Biplav on 18th, Purokasto says that loudly in court, you sit quietly without questioning him on that. What the taxi driver says, what the panwala says, irrelevant.
not-
So you start with your best point.
I'm just, my lord, without any.
Start with your best point.
Lordship, what I'm trying to submit, my lord, is this 164 statement which has been made by Bernard, my lord. Under what circumstances was it made? Lordship,
Let us first see in Bernard. So you're going straight for the jugular.
First
You're
of the
going for
164.
164. If you're successful in dislodging 164,
that would.
case against Boni will also go. Now, first let us see what you say about 164.
Lordship.
And then we'll come to the 164 itself. That will be in your 313.
In 313, I have essentially, my lord, denied it by saying that I did not so.
Let us see your cross-examination of the magistrate.
It's 313. Lordship, that is at page 318.
Magistrate, page 313.
Begins at 313, Lordship. The cross is at 318.
318. She was PW?
My lord, PW 32.
32.
32.
See, when the matter is interesting, you don't feel drowsy. So generally, in this court particularly, we are out of habit in the afternoon. Or particularly I am, not my brothers with me.
Page 318, my lord, if I may just read. Towards the bottom, lordship. On the day of holding the inquest report over the dead body, only one accused, that is, accused Bernard Lingdorfer, was present in the spot. I cannot. This is my lord. From the second paragraph, lordship. I have recorded the statement of accused Bernard Lingdo, Exhibit 19, in Khasi language. I have put the question to the accused in Khasi and also in English, and I have translated his answer into English. The accused gave his answers both in Khasi and English. The accused confessional statement was recorded in the courtroom, which was locked. I have given the accused reflection time, and during reflection time from 10:30 a.m. till recording of his statement at 3 p.m. Accused was in the courtroom only, and all.
Let us see the two biggest points that you make in the cross-examination.
Lordship.
One is, her answer is, I do not agree. This was a lady who was the
Lordship, yes.
I do not agree to the suggestion that as during the reflection time you were kept in the courtroom. This implies that you were threatened.
Lordship.
That is one angle of your question. The second is, it is not a fact that I have recorded the statement of accused without the accused understanding the implication of the same.
Lordship, yes.
Implicit in this is your admission that you made the statement. Do you get it? It is not a fact that I have recorded the statement without the accused understanding the implication of the same.
Yes, I understand, my lord. That says that.
So
the statement
therefore,
was-
there is admission in your question that you made the statement.
Lordship, yes. I quite see that.
Then
But what I
there
am.
was no interpreter at the time of recording. I was not, because I was always able to communicate. Not a fact that I have not recorded the statement of 7. Not a fact, these are the stray lines that you give without any.
But what I am trying to, my lord, submit, subject to correction, my lord, is that the magistrate says that the entire statement was like recorded in Khasi. Here, my lord, there is no statement recorded in Khasi. So what has happened to that original statement?
No. You spoke in Khasi. She translated and wrote it in English.
The second paragraph, my lord, of the cross.
Yes.
I have recorded the statement of accused Bernard Lingdo, Exhibit 19, in Khasi language.
No. Read the next sentence. Don't miss out the.
Lordship, yes. I have.
Don't be mischievous, please.
No, I have.
I have put the question to accused in Khasi
Lordship.
and also in English, and translated his answer into English.
Lordship, yes.
There is your answer. I have translated his answer into English. Not that I wrote Khasi and then from Khasi I translated. I translated his answer into English. That's clear. The accused gave his answers both in Khasi and English.
Lordship, yes.
So it seems that you are able to converse in English also.
Yes.
There is no evidence on your side that you do not understand English.
A suggestion is put, my lord, that there was no interpreter because perhaps the accused could not have.
But there is no evidence that you do not understand English. She asserts the accused gave his answers both in Khasi and English.
Lordship, yes. But
So
from
you are
the.
conversing in English.
If that was the case, my lord, then in my of course, my lord, like in the 313, my lord, questions was asked in both the languages. Both the answers in both the languages were available in the record.
Yes.
For the
That person took extra care to do it. Even that is not done. Most of the times you'd see, you have appeared in many matters, you will not find the 313 recorded in thing.
vernacular.
Sometimes, when there are key answers, then the key answers are recorded in English script, in the vernacular. For instance, if it's Hindi or Bengali, it's a key question to which there's a key answer. So the exact words of the accused are indicated in English alphabet, Roman alphabets. The translation follows. That's the understanding of the judge of the answer by the accused.
Not
So,
my lord, because my lord, the confessional statement ought to have been recorded in the way the accused has made it, and in his as exact, in his words which he has stated. If he has stated in Khasi and in English, but here we only have the English and no
she says, I translated in English.
lordship, yes.
Very well. Now, you could have picked up on any of your questions, on any of your answers. The entire statement was before you. You could have said that in response to this question, I actually said this, but you mistranslated it or you misinterpreted it. You have not done that. It's not just one question that she asked you. There are several questions. You have not picked up any of that. You asked a vague, general kind of thing to raise some doubt when there is no defense. It's like a smoke screen. One could have understood that this particular question, you have put it, I actually said this, but you misinterpreted it to be this. One could have got the drift of what you are saying. That is not it. Plus, the way you sign shows that you're capable of reading and writing English. Your signature is such, it's a practiced, regular signature.
It's only block,
It is.
name written in full block
Name
letters.
written in full. So is mine.
Lordship, yes. Which is also not matching with the signature in the inquest. So that only with the signature part. Lord. Those are the two places where the signatures
So,
appear.
your best point is this.
No, my lord, what I'm trying to say, Lordship, is that firstly, my lord, is that it was not recorded in my humble submission, my lord, that if the accused gave his answers in Khasi, those answers ought to have been put. So the exact words of the accused.
Let us see that is the point that you make, that no Khasi recording.
Considering, my lord, that she said that she recorded it in Khasi in the first line of the.
So I put the question to thing and I translated answers in English. That is the entirety of what she says.
Lordship.
Yes.
The second, my lord, is that two very crucial questions, my lord. Here, my lord, the Bernard was arrested, detained on 19th.
So
Arrested
you
on.
finished with the statement.
No, on the statement only, my lord.
Yes.
One is the language. The second, my lord, is that the Bernard, my lord, he was detained on 19th, arrested on 20th. And there, till the time of recording his confessional statement, he was in custody, my lord. And that was recorded on 7th. Not
7th of March.
Yes, not immediately after, but not a large lapse also, I don't say a lot. But there was a reasonable gap.
Yes.
And in,
no, but he was still in custody.
he was still in custody, my lord.
Yes.
And in that situation, the magistrate ought to have asked, my lord, that what kind of custody are you in? What happened in the previous dates of custody?
Those are there, part of the questionnaire.
No, two very quick questions, my lord, is that why does he want to confess? Lordship will kindly see, my lord, someone is in custody for 2 weeks or so, implicated in a offence under 302, another serious nature, my lord, is produced from custody, brought to the court, and he is given reflection time. I'm not 10:30, 3 o'clock, my lord.
No, we are not on reflection time.
Yes.
Now let us get into the basis for 164.
Lordship.
Which is why it has now become stricter, that it is now to be recorded, videographed.
Lordship, yes.
All statements under 164, particularly confessional statements, have to be videographed. That's number one. Now, 164 previously could be before executive magistrate, but because executive magistrate is not a judicial officer, now it's compulsory to go before a judicial magistrate. Now, judicial magistrate, what is regular work that the judicial magistrate does? Judicial magistrate judges, dispenses justice. So, the work is entrusted to a judicial officer so that he will be disinterested, he will be dispassionate, and he will understand what the implication of the statement is and ascertain whether these circumstances are conducive for the statement to be made. That's why all of this is entrusted to a judicial officer. And that is why all those parameters and all those questions are indicated in the 164, the form. So, if it were, layperson, if it were a bystander, if it were somebody else, then you can say that, why was this done this way? But when it is a judicial magistrate, he or she is expected to know. And also, there is a warning which is given that are you aware that this could be used against you at the time of trial?
Yes.
All of that is done.
Only
Right?
two questions, my lord, if in my humble submission. One would be, my lord, that why are you giving the confession? Or under what circumstance are you giving the confession? Whether it is out of repentance or out of whatever it is. So that one question which was not asked, my lord.
There are several lines of cases on these, but nothing very sound. Anyway,
So that is one question, that why are you giving the confession? And the second question which ought to have been asked by the magistrate, my lord, to give credit to the 164 was that, my lord, that the magistrate never gave any assurance to the accused that he, in case he doesn't make the confession, he will not be sent back to custody. That is very crucial, my lord. That someone is brought from custody, and of course, my lord, 164 is recorded and on the request of the IO.
someone is brought from custody to give a 164 statement. He has to go back to custody.
No, police custody, I'm saying, my lord. But it was never told to the accused.
But he was in judicial custody at that point in time. Or was he in police custody?
He says from jail, it's not very...
Yes, so we don't know whether he was both police custody and judicial custody can be.
Lordship.
Because beyond a period of time, they don't keep you in the lockup.
That probably has to come from the remand or from the...
Whatever it is, we don't know. It's not something that.
No such either judicial or police custody, my lord. It was never told to him that in case you don't confess, you will not be sent back to custody.
Why? He came from custody, he was going back to custody. Why should the magistrate lie to him?
No, my lord, I'm saying in
Whether he made
police
the
custody, my
statement-
lord.
Did the magistrate have any authority to deal with his status at that point of time? Magistrate's job was only to record the statement. What you say is that there are some statements, you'll find it in particularly UP cases, many cases emanating from UP. There's a different thing to it, twist to it. What you're saying is that a person, when he is in custody, can therefore never make a statement on 164.
No, my lord.
Then,
But that assurance has to be given to him.
what assurance will be given?
That in case he doesn't confess, he should not be sent back to police custody, my lord. That he will not be sent back to police custody.
Where is the requirement of that? Where is the requirement in law?
Some judgments are there. I'll try to...
Anyway, we'll
that
see.
is-
Many of those, yes.
And the second thing is, my lord, that why was there such a delay
Of
of bringing Bernard to record his confession? If he was arrested on 19th, and on 19th itself, Purkayastha and all these people had further, my lord, said that he was there.
Anyway, now
And he
let
was-
us say there was a delay. Does the delay detract from the statement?
No, but it may give...
The delay. Why? If it had been on 10 days earlier, you would have said, why was it 5 days later? If it was 20 days later, you would have said, why was it so long later?
The delay has to be, my lord, seen in a
No,
certain...
there's no requirement for delay. Your statement is there. Whenever you are ready to make the statement, you are in custody. Please try and understand. I don't know how much of reflection you people do. Sometimes reflect, sometimes shut your eyes and don't read and think about the matter. Imagine yourself in custody. Imagine you have done something or have not done something. You're in custody for a long period. You have had time for the last month and a half to regret, to be remorseful, and then now you want to make some statement that will ultimately extricate you from the main charge or help in a more sympathetic treatment of you ultimately. This is why you make the statement. Sometimes it could be pure guilt, pure remorse, but ordinarily this would be it. So whenever you felt comfortable, you made the statement. Why it is 20 days? If it were 3 years later or 4 years later, one could have understood. But you must understand over here in our country, we don't have adequate resources for the police. The police population ratio is terrible. We don't have proper investigators. The investigators are not trained. The same man has to do VIP duty. He has to do a bandobast on a special occasion, and then he has to also go and investigate. So there are difficulties which a third world country faces. But that does not mean that you use these difficulties as an excuse to get off. We are looking, therefore, more at the substance, not the form. Say, for instance, there is a delay in the lodging of the FIR. That requires an explanation. But delay in making statement while you are still in custody depends when you are ready to make the statement. You may not have been willing to make the statement before. You may have become willing after a period of a month or so. We can't go into conjecture. But once the statement is there, the delay in making the statement does not detract from the quality of the statement. We are writing delay, but it's useless. Yes.
My lord, my underlying submission would be that, my lord, that failure to cross-examine the witness may not, my lord, by itself give the 164 full creditworthiness. What I am trying to say, my lord, I am not trying to blame the defense counsel. I am trying to say, my lord, the courts, if it has to base the conviction by relying on the 164, should, my lord, by itself look into the circumstances under which the 164 may have been
We've explained the circumstances to you. Anyway, yes, carry on.
Lordship, the fact remains, my lord, that in the 164 of Bernard, he does not make any confession per se. What he makes, my lord, is admission to incriminating facts.
Exactly.
And
So does Bonnie.
Lordship, yes.
Bonnie also does not confess in that sense, confess to the commission of the offence,
Lordship.
but admits certain things from which certain inferences may be drawn. Let's put it at that.
Lordship. So, my lord, my humble submission is that, my lord, on the basis of these admission of incriminating facts, whether, my lord, these admissions can be used to complete the chain. Because had I made a false statement, then that would have been used against of me. But here I have not made any false statement per se. I have simply not confessed as to my own guilt. So whether, my lord, on that statement, the chain is otherwise complete, lordship. In my humble submission, my lord, that if we, my lord, take out my 164 statement, what is left is, my lord, that Purkayastha says, as well as, my lord, Roger, they say, my lord, that on 18th evening, Bernard told them that they were together on 18th evening. Thereafter, he left in his own respective direction, and the deceased left in a different direction. He does not say, my lord, that they went to the graveyard together.
That is why the statements are so credible. If people wanted to frame you, if all these people together they wanted to frame you, their quality of their statements, what they said would have been different. Over none of them, they appear so natural and credible. They don't link you or Bonnie to the offence at all. They only indicate what they have seen and heard. And therefore, it is inconsistent with anyone trying to frame you, anyone trying to, put the burden of guilt on you. No one has so much as pointed an accusing finger.
Lordship, yes.
None of these people have pointed an accusing finger at you. Except for those witnesses, IO and things like that. They are, of course,
Lordship.
police witnesses, most of whom we don't believe.
Lordship. My lord, and my lord, that being since it is not a confession per se, my lord, can, my lord, this honorable court use that to convict me without any material evidence suggesting my involvement or pointing to my guilt, my lord?
That's your perception, yes.
Because had I confessed that yes, I have done it, and that was otherwise corroborated by the other witnesses, my lord, may not be in the actual commission, it would not be possible, lordship, but in the surrounding circumstance, and then I say that yes, I have done it, which is lordship finds to be true and voluntary, then, my lord, of course, that can be the basis of conviction.
Yes.
But here, my lord, I do not confess per se, lordship.
Yes, you do not confess. It's not really confession. We've said it over and over again. Yes.
So, my lord, that if because I admit my presence in the graveyard, lordship.
Very good. You admit your presence over there. Once you admit your presence, sir, is it not incumbent on you to explain what happened? You admit your presence. You admit that the person died while you were around, there or thereabouts. Isn't it incumbent on you to explain, well, a snake came and bit him, or Martians came down, suddenly killed him and took off in a spacecraft? Something from which
He tries to put the blame, saying that, my lord,
he tries to put the blame.
saw him with a rope
That
and-
part of it we cannot take.
Lordship, yes.
That part of it we cannot take your statement.
Lordship.
Yet, we find credence in your statement indirectly because ultimately he was found, the medical examination shows that he was strangled to death. So even though we cannot use your statement against the co-accused, but even to that extent, it substantiates the rest of what you said.
But then again, my lord, the time would be a factor, lordship.
Yes,
If we
what-
have to base it on the medical.
Medical is when there is direct evidence. Medical evidence, all of those expert evidence, all of them fade into insignificance because one would have understood if there is any principle that when it is said 48 hours, it can be only 15 hours more and no more. If there is any law, then of course we are precluded. But there is nothing of the kind. It's an expert opinion of a person who is trained, who is skilled, who is experienced, and who, on the basis of his training and his experience, should be able to indicate.
It's an approximation, my lord.
So it's an approximation.
Lordship.
Now, once you show that there is no law, you do not show that there is any law, checking the approximation, when there is ocular evidence, direct FSL evidence is also disregarded. I'm sure you found those cases.
Lordship.
Yes. Direct FSL report is disregarded when there's ocular evidence.
But
In
here,
fact,
my lord,
if you may have heard the matter in the morning, where that CBI trial was trivial investigation was directed.
Lordship.
The principal reason why that was done is because an executive magistrate who is employed by the same government that employs the police went to the place of occurrence within 3 or 4 hours of the incident and found a pistol next to the dead body, picked up the country-made pistol, found it to be junk, found it to be rusted, found it to be non-functional, so much so that had to beat it with a stone to get the magazine out. This is the ocular evidence. Forensic Science Laboratory says it was a functional pistol from which bullets had been fired.
that's a glaring inconsistency.
All right? So that's FSL. And much more to rely on than estimation.
Not sure.
So therefore, when there is ocular evidence, we can take that.
But here, my lord, what is the
But
ocular
we
evidence
take
which...
that, we take that point that even your friend has made, that time of death as per the report.
Because that is the only document, my lord, which brings the time of death.
Yes.
Apart from that, we don't have anything
Nothing
to...
else. Nothing
Not
else.
sure. So my humble submission would be approximation, definitely, my lord, but not to the extent of doubling it. That, my lord. So, my lord, if as per my submission, my lord, if the medical says strangulation and the time of death, as per the medical, in its letter, my lord, is
Sorry? Didn't hear you.
the medical report, my lord, the postmortem report says that the cause of death is because of strangulation.
Strangulation, yes.
Lordship. The same medical report also says that the time of death was possibly 40 years.
Again, please see. Strangulation, the report is by observation,
It's definite. Lordship is.
whereas estimation of time of death is estimation, not observation.
Lordship, yes.
So the qualitatively they are different.
Lordship, yes.
So I can disbelieve or disregard the estimation, but I have no right to disbelieve or disregard the observation together with the physical presence of those marks which have been referred to.
Lordship, yes. But to what, had it been a situation, my lord, where the death, as per the prosecution story, was 1 week before, and the medical officer says 2 days.
Medical officer,
The medical postmortem, the doctor conducting the postmortem says that the deceased died 2 days before, whereas the prosecution story is, say, 7 or 10 days, my lord. In that situation,
that may or may not have been difficult depending on it, but you know, difference between 2 days and 4 days is hardly anything.
because
2 days and 10 days, 2 days and 18 days, definitely.
Lordship, yes.
The
But
greater the difference, the more circumspect you have to be. The more you have to lean towards the scientific estimation based on scientific knowledge and skill in the absence of anything else. But yes,
so my lord, my submission is that to extend it to double the approximated time may not be, my lord.
doubling 2 plus 2 is also double.
10 plus 10 is all.
10 plus 10 is also double. Million plus million is also 2 million.
Lordship, yes.
So the difference is what is the
Range. I understand,
what
Lordship.
is the multiplier and what is the multiplicand.
Lordship, yes.
All right. So 2 into 2 approximation and 4 into 2 approximation are completely different.
Lordship, yes. But the prosecution also had an opportunity
Yes.
to further examine her, that
Further examine.
the doctor, my lord, to the effect that maybe that is that is only an estimate.
He has given his opinion. He's given his opinion. There is no rule, as we said, no law, no rule, or nothing that you've been able to cite that, as we say, 2 days means up to 36 hours. You are up to maybe 52 hours or 56 hours, and you can't stretch it to 96.
Not sure. That I have to, of course,
You have not.
look
This we've
into.
been harping from day one.
I tried, my lord, but to
No,
directly
you will
do
not.
that, it's very
Because
difficult to.
what you will get everywhere is that if ocular evidence supports the case, and medical or other opinion does not,
The ocular prevails. There is no, my lord.
there are cases where rape has been proved without tear of hymen,
Not sure. Yes.
in full insertion without tear of hymen.
Not sure. Yes.
It's an odd case. It happens in an odd case. Yes.
Now, my lord, the another aspect on the 164, which, my lord, I may be absolutely wrong, is that it should not have been recorded in the question and answer form, which basically, my lord, shows that the magistrate, keeping in fact consideration, my lord, that the magistrate knew about the surrounding facts of the case
Let
because,
us see the questions. Let us see the nature of the questions.
lordship, those were leading questions in my.
Before a magistrate, there is no leading question. The court does not ask the leading question.
No, but she knowing. No, what I'm trying to say, my lord, is that she knew the facts and circumstances. She asked me pointed questions.
Let us see. Let us see. Where is the 313?
The 164, my lord,
Sorry,
begins at page 37, my lord.
Bernard 164, page 37.
Lordship.
The printed part.
Lordship, yes.
Let us take from question number 6.
Lordship.
6. Perfectly innocent question. You have been produced today from jail for recording your confessional statement with the murder of Biplav Das.
That is, my lord, yes. That
Are you aware of his death?
he says yes.
Leading question. He says yes. Then, if you are aware about the death of Biplav Das, can you tell the court how Biplav Das died?
Lordship, yes.
So, it emanates from the previous question. He answered it.
But not to the aspect of how he died.
Not to then look at the question, next question.
Lordship.
He did not say anything about how he died, and the judge did not go on saying, but how did he die?
Lordship.
What the judge does is picks up on the answer. Did you ever visit Biplav at his residence, Lashumer? Because Lashumer is indicated as his residence in the answer.
Lordship.
Then he answered, yes, I visited. When did you meet Biplav? At his residence.
Lordship, yes.
He answers this. Then, because he answers 9, the question is whether Bonnie told Biplav the amount of money he required in your presence. Then, because he had finished off
Till Umsosun.
till that place, to Bonnie's shop there. Where have you gone after leaving the shop of Bonnie at Umsosun? Then it's your unilateral answer. All this length, it's your unilateral answer. Then, what more do you want to say? There's no pointed question. There's no question that did you go to the graveyard? There's no question did you go to PCO at Maulai? There's nothing like that.
Lordship, yes, but the statement ought to have been recorded not in a question answer form, considering that she knew, my lord, that these are the.
No. All these questions come out from this. That you could have said she should have stood on the table and he could have been on the almirah while answering.
No.
It's as absurd as saying that.
No, because
All the questions follow from the previous answers of the person. Nowhere has the line of questioning guided him to say something, to explicate anything out of it. What more do you have to say? Nothing else. Since he talked about residence, since he talked about going to Bonnie's shop, just follow up, nothing else. Yes. And you'll find the previous part probably over here. If you come to page 36,
okay.
and you see the
Bolded lordship.
entry over there. middle of the page.
Lordship.
You are not bound to confess by law. In case you do, the same will be used against you as evidence in this case. After explaining this to the accused, I believe whatever statement given by him was voluntary, whatever. Again, see the previous page,
Lordship.
number 3. Is there anyone telling you what to say in court? No. 4. Do you know what you have to tell the truth in court? Yes. 5. You are not bound to confess. In case you do, the same will be used against you as evidence. After this, what do you want to do? I want to confess.
The next question should have been why, my lord? Because
Why? Why? Why should the judge be interested? Why?
no, because under what situation?
Certainly not. And he did not confess. Despite saying, I want to confess, he did not confess.
He did not confess.
The judge still did not ask, where is your confession? The judge let the statement be. Let us see about bodies.
It begins at 19, Lordship.
Before 19.
The 21, my lord, from the
21.
questions part.
Same thing.
Same thing, my lord.
And please come to something like page 20. Just
Lordship, please.
see number 4. I have satisfied myself there is no police officer in the court or any place. These are all printed form. But at the end of the printed form, she has signed. So these are the checklists which the form reminds her what to do. She has signed. There's a presumption that she has followed it. In this case also, if you see page 23,
Lordship.
do you know you've been for recording? Yes. Then what do you know about the case? Nothing else can be asked. Then he left, we reached the graveyard. What did you do in the graveyard? Because he said that we reached the graveyard. What did you do in the graveyard? Then your unilateral statement. Then 9. Very perfunctory. What more do you want to say? Then where have you kept the mobile? Because the mobile comes from question answer to 9. Bernard gave me the mobile and went to sell the mobile to one person, telling him, however, whatever. I have nothing more than this. Yes, what is your next point? Or whatever else you want to say on 164? Cases you will cite right at the end or right now?
I'll try to put it at one shot, my lord. In one shot.
In one shot? Just indicate the points and we'll make up that. In 164, you'll get several cases in your favor. There's no problem.
So, my lord, my like an umbrella submission, my lord, in 164 would be that, my lord, the 164 was not voluntary.
Was not?
Voluntary, my lord. Of course, there was no
It's a submission
cross,
process.
but that it was the duty of the, my lord, the magistrate as well as this honorable court to
Yes.
see under which circumstance this considering that they were in custody for
Anyway,
so many days, my lord.
anything else?
On 164, my lord,
After 164, come to your 313.
not-
No, before 313, come to your cross-examination of the magistrate and then to 313.
not so cross-examination of
Cross-examination of magistrate you've already shown properly.
Lordship, yes. That is at beginning at
Yes,
313.
that you've already shown. Now you come to 313.
That would begin at 371, my lord. And the
Page 371.
is the start, my lord. And the
Because your retraction is not like Bonnie's. Bonnie's is a more substantial retraction.
lordship. That is at 386, my lord, the typed version.
386.
Only before, my lord, going to the 164 part, only one point is that, my lord, in the 313, although he does not deny in the cross of Mr. Purkaista, in 313 he makes a denial to that effect that he was not.
Yes.
As well as with regard to the PCO, he says that he did not
Let
go.
us see.
The magistrate question is at question number 13.
Yes. We look at all the questions.
Lordship.
The name is Nirvika, is it not? Everywhere it's misspelled.
It's Nirvika otherwise.
Nirvika. First and foremost, question 5. I know Biplav Das twice or thrice, but we are not close.
Lordship is.
So you know Biplav Das. That's of relevance. Then PW6, which is Nirvika.
Lordship.
The deceased told us that he was in
Maukar.
Mokhal, which is that. What is the name of the place?
Mauro Maukar.
Mauro. With his friends from Shiliguri. And also told her that he will be meeting you, Bernard, in the evening. What do you have to say? I know nothing about that. Now let us come slowly to Peter, that she called your number but it was not pick up. What do you have to say? I know nothing about that. You could have said, no, she did not. I had my mobile. I will show from call records that she did not call.
Lordship.
We have to take everything into consideration, not pluck out some stray sentence from here
I'm not for a moment trying to.
and not read the next sentence. Auto rickshaw driver said that on 1999, 6 April 1, I know nothing about that. All right, 19th is the wrong date. Just because it's the wrong date does not detract. Anyway, you say nothing. R.K. Sangma, who's R.K. Sangma?
The,
17.
PW17. That you and others dropped Viplav at Police Bazaar on the evening of 18/2.
that RK is Roger, basically. Roger.
Rogers. I know nothing about that. Could have denied it, sir.
I understand.
Could have denied it. I deny it. What does Nagam tip paying shapang kata mean?
Basically means I don't know, my lord.
I don't know.
Just a thing out.
It does not mean I deny.
No.
No.
I don't know anything. I don't know it.
PW 17 also says that the owner of PC at Maulai Mauro informed him that you came to his PC on the night. What do you have to say? I did not go to the PCO. There is denial over here, but not at the relevant time. We take this into account, don't worry. Rajan Chetri said that you, Bernard, one of his friend, telephoned him to come and depose in this case. What do you have to say? What is this? We don't understand the meaning.
Not very relevant.
No, not relevant at all. Marbod Lindo. Who's Marbod Lindo?
Marble Lindo, my lord, is the
PW 31. Yes.
PCN. Yes.
PCN.
Cameraman.
Yes. Cameraman.
PCN. my lord. At the time of recovery of the
Cameraman. PCN News. Na?
PCN, lord.
PCN News. The presence of the spot, a dead body was to be exhumed, and you again showed the spot and the police did. The spot is already exhumed. What do you have to say? The police took me to the graveyard, but I did not show or point anything. We more or less accept that you did not. Srimati Chalam has stated that on 17,
Magistrate, my lord.
yes, that you met Biplav on 7th and 8th February at Police Bazaar, and you had both. I did not state anything as such. Then pray, how is your signature on the statement? How is your signature on the statement? You could have said something else. I did not say anything as such.
No, because this is not a question as to whether I made the statement.
No, it's a question. As stated in our evidence that on 17-3, you stated before her that you met the victim on 7th and 8th February at Police Bazaar and that both of you had coffee at Pineborough Hotel. What do you have to say?
Not
I did not state anything as such. Stays in your face. And the credibility of the rest of your submission or the credibility of your conduct depends on this. Then you stated the last time you met the victim was on 18-2 near Delhi Mishtan, and you took him to accuse Bonishab, who is your uncle. What do you have to say? I did not say anything like that. So all of them are that you along with Lhasa. I did not state that. Went to Mauro, reaching Mauro, Biplav made a phone call. I did not state. State before that when you returned from buying cigarettes, you saw boning. I did not state that. That you asked Boni whether he dug the grave, that accused said the grave is already there, which he had dug in the morning. I did not state that. Very good. B.C. Thakur, that you led him and others to the home of accused, where a silver-colored chain spectacle was seized from his own. What is the significance of the silver-colored chain spectacle?
Maro, that was allegedly the spectacles belonging to the deceased, which was never proved.
Belong to deceased.
However, it was never proved.
If I may clarify on this point, Manoj, yesterday when we had
Later,
read the-
not now. Yes, and this was not produced as an exhibit or anything.
It was not identified properly. Sir.
The IU stated that it belonged to Boni.
Yes, madam.
My lord, yesterday when we had read the cross-examination of the investigating officer, it is stated therein that the spectacles and the wristwatch belonged to Boni himself.
Went to Boni.
Yes, my lord.
but it was not exhibited or anything.
No, my lord.
Lordship, I just want to point out that Bajikti is a watch, Lordship, a silver watch.
Yes, that's what I'm saying. Watch and spectacles. The two things were recovered, and the IU has stated in his cross that it belonged to Boni Bhava.
What they exhibited?
They were exhibited, my lord.
No, Lordship.
No, my lord.
They have not been linked to the deceased.
No, my lord.
The seizure list was exhibited.
Huh?
The seizure list was exhibited.
Well, seizure list was exhibited, but have those items been linked to the deceased?
No.
Because no one has asked. If it had been, they would have asked. No.
It has not been exhibited.
Very well. It is exhumed.
Not sure.
Yes.
So, my lord,
At least Boni has said something about, reflection time, waiting for the whole day, not getting a chance, and then having been fined. Believe or disbelieve, at least he said something substantial. You have said nothing at all.
all denial by.
Apart from, I don't know, not denial.
Yes.
Denial is something else. I do not know. Of course, yes. To the extent that you said, I did not say, that is denial. Yes, next point. How many more points do you have?
So I'll take another, my lord, hour. If I may pray, it can be taken up on the next.
And how many judgments will you cite?
2 or 3, my lord, only on the 164 aspect mainly, my lord.
Tell us when.
Tomorrow. You can do tomorrow. Subject to, my lord, because she's coming from outside.
Only for tomorrow, I'll pray and I'll seek for an accommodation, my lord, because tomorrow is Raksha Bandhan, my lord.
Raksha Bandhan is today.
My lord, in our custom, the Purnima is starting at 9 o'clock tonight. So the tying and everything, all the customs will be performed tomorrow.
Yes.
That is why I just seek a little accommodation. And my lord, my part is almost over. So I will be attending the future hearings through video conference if it is feasible.
Yes, absolutely.
She can attend also tomorrow.
Absolutely.
If tomorrow for any
Tomorrow
clarification.
I am having difficulty because there will be a lot of relatives and functions.
Next
It's
week,
okay.
my lord,
Absolutely.
And it has been fixed today and yesterday.
Lordship, as a lordship, please.
And she's done her part, so let us not.
No, not at all.
Plus, she's at the receiving end. She's at the receiving end, we have to be more lenient.
Lordship. Monday?
What date is Monday?
Fourth. Monday is
4th.
Fourth.
It has to go beyond. It has to go beyond 2 weeks. I will not be there. It has to go beyond 2 weeks. Other part, the matter will appear a fortnight hence. The date will probably be not before 19th. Give it 20th. 18th is a local holiday.
Local holiday, Lordship.
For what?
I think so. It's Unitarian Day.
Is it on a fixed day or does it?
No, it's on a fixed day. Every
on a
day.
fixed day? That's very good because yes, and there's very little time after that. So hopefully on 20th, and which means that I have to finish my observation part of it before that, so that judgment can be delivered. After that, I won't take up serious matters.
We'll also try to make good our argument, my lord.
Yes, just finish the two of you off and then. Because it will take a lot of guts to convict you. The easier course is that what was that. 2 months ago. Yes. Please keep this in a separate plastic folder like I told you yesterday.